Good morning, everybody. My name is Dean Zenick. I am president of the Palm Beach County Bar Association. Thank you for joining us today for the Palm Beach County Bar Association's Town Hall with Chief Judge Krista Marx regarding Phase 2 recovery. If you have any questions today, please use the Q&A feature. We're going to start with Judge Marx, Chief Judge Marx. She's going to give some opening comments about what's going on at the courthouse, the Phase 2 recovery, how we are going to be opening up. And this is part of the Vision 2020 Palm Beach County Bar Association focused on recovery. We're here to help get everybody back to the courthouse, get their practices back in step. So with that, I will introduce Chief Judge Krista Marx, and she can start with that, and then we'll go with question and answer.
Good morning, everybody. Thank you so much for taking time out of your schedule to join us today. I'm sure there are many questions. I find every time I issue a new AO, certainly in the courthouse, there's lots of questions that swirl around. You'll see from the latest AO that from the directive from the Supreme Court is that we start taking steps to get back into how we used to conduct court proceedings. I don't know that that's ever going to happen. I think some of the things that we've learned during this tumultuous year is that we can do it better and smarter, that we can work smarter, and we'll hang on to some of the things that we've learned during this year. But certainly things have slowed down tremendously, and we all know that the wheels of justice need to get spinning a little bit quicker here. So in Phase 2, some of the major changes are simply this, that when we started off, Dean and I were talking before we started the meeting today, and Lynn, and you know, just talking about all of us trying to figure out how are we going to do this remotely. And yesterday I was talking to some judges, and certainly as chief, I've had to be a little giving them a lot more direction and telling people how we're going to do it for the sake of uniformity. And one of the judges said, you know, that one of the best things we did during this time was to direct that we all move to the same platform. Because we all know this, in the beginning, it was just super bumpy, and there would be, judges would be taking telephone calls on some hearings and then hanging up and doing WebEx, and then the next hearing was Zoom. So we sort of moved to a uniform way for all of the judges to conduct those hearings. And I think that helped tremendously. So in the beginning, a lot of the essential hearings, which are enumerated in the administrative order, we were pretty much mandating that those be conducted in person because we just were not ready or adept enough to figure out how to do it remotely. And then we quickly were able to do even first appearances remotely. And so you'll see with these new iterations of the administrative orders that the directive is still, let's do as much as we possibly can remotely. And I have broadened the class of cases where it can be conducted in person if it's just not feasible. So that's the direction that we're going into. And I think what we're going to mostly see is a lot of hybrid hearings. And our IT department has been really busy making it much more easy for some people to appear remotely and for some people to be in the courtroom, and to make sure that whether you're appearing on a television screen or you're the individual at the podium in the courtroom, that all individuals get to see and hear what the person is saying. So for a while, when we were doing hybrid, particularly in the criminal arena, I think we were having difficulty with the attorneys. We're only hearing through the judge's computer what the person on Zoom was saying. So we've become much better in the courthouse to conduct these hybrid hearings. And everybody now has a large screen TV in your courtroom. And I think that's gonna help tremendously. And you know, there's just hearings where maybe a student is up in Tallahassee or Gainesville. It doesn't make sense that they would have to come all the way to Palm Beach County to be on the stand for 30 or 45 minutes, or a lot of those people, even experts, that instead of flying them down, maybe we'll continue to use that as we move forward. I certainly think that we're going to continue to do 845s and briefer hearings, that the new wave will be that we will continue to conduct those hearings remotely. I was saying earlier that I think we're a long way off from jury trials being conducted via remote means or long evidentiary hearings. It's become very complex from the judiciary's perspective. I was saying that for the bar, to not have to get in your car and come down to the courthouse and park and walk through security and then sit in the back of the courtroom waiting for your hearing, that there's just so many advantages to it. But I'm hearing from some of the members of the judiciary that particularly when it entails a evidence intense hearing or case, that it is much more time consuming on our end, because you're just used to people showing up in the courtroom, they pre-mark their evidence, they approach, they give it to you, and so it is a lot more time consuming. And certainly with no trials, there's a lot more hearings going on, so it's pretty intensive for the judges preparing for all of those special set hearings. But one of the biggest things that we're going to do here in phase 2 is jury trials. So we are going to approach that in a very measured way. And I have asked a few of our most experienced trial judges to select a handful of cases in their divisions that would be considered garden variety. So nothing that's too going to cause too many issues with prospective jurors. And I meet with them every couple of weeks to talk over the dynamics of how that's going to roll out. So we're basically doing trial run. And so of course we're starting in felony. And so 2 or 3 judges are picking a handful of cases from their divisions, and we have begun to summons individuals in the community to come in for that jury work, which will begin in October. And prior to that, I will be bringing in jurors for a grand jury, because there are something like 20 first-degree murders that the grand jury needs to make a determination of whether there'll be an indictment in those cases. And I started with grand jury because it's a much less complex jury selection. And we're looking forward to seeing what the yield's going to be. So I know a lot of you are aware that prior to the pandemic, we had about a 30% yield. So we sent out 1,000 summons and about 300 people would show up. And so we're anxious to see what that's going to look like during this time of COVID, how many people are going to actually show up. And we'll get a good idea when we see how many of the individuals. We summoned 400 people for the grand jury, and that'll give us an idea of what yield is going to look like. I also asked a couple of our most senior experienced civil judges to pick a couple of cases, and those will be heard the first week of November. So I wanted to see if there are hurdles or things that we haven't anticipated in the civil arena as well. So we have been busy making sure the courthouse is as safe as it can possibly be. Obviously, my top priority is to keep everybody safe, particularly the citizens that we're going to start bringing in for juries. And it has been complicated, and every day we think of something new that we've got to do to make sure that we keep everybody safe. And we're buying all sorts of equipment. We just ordered the clear mask so that jurors, you'll be able to see their facial features. We're running through scenarios of how that jury questioning is going to go. I want to make sure that the attorneys are able to see the nonverbal cues of the jurors. We certainly can't have them remain masked and have attorneys miss out on what is expressed nonverbally during questioning. And we're going to be providing masks as well as shields for everybody in the courtroom. We are marking off the big extra large ceremonial courtrooms for social distancing. In all the jury rooms, we have 2 air purifiers. We've gotten these wildly expensive machines that will come in and sanitize. We are taking tremendous steps to keep everybody safe. And I think it's going to be a very interesting process. We will be using the jury assembly room. We're going to lock down, we're going to use the entire cafeteria and courtroom 2D. So we're going to have the prospective jurors in 3 different locations, and prior to them being sent upstairs for jury selection, I will be downstairs going through some questionnaires and making sure that anybody who should have been disqualified and actually not summoned, that we don't send them upstairs. That would be individuals that aren't United States citizens, or don't speak English, or have been convicted of a felony and have not had their rights restored, individuals like that. So we're hoping to send upstairs individuals who it's really a good, clean panel. So it's going to be very challenging, but we're looking forward to it. I also am keeping a strict eye on what it's looking like in the community. We were on a great downward trajectory with our numbers as far as positivity rate. And then in the last couple of days, we had a bit of a spike. So I'll be keeping an eye on that. And I certainly hope we're not going to have to cancel the jury trials, but if the numbers don't support it, then we'll have to pull the plug on it. So I hope that doesn't happen. I'm anxious to answer any questions that anyone might have.
Judge, let's start with mediations, which was your most recent, the most recent AO that came out this week. You added mediations to the items that can be had in person, and I guess specifically the requirements are that section 4 of the AO be followed. And I guess the question is, since mediations are outside the courthouse, or most of them are, and the section 4 has to do with in courthouse safety precautions, what precautions do we need to take outside of the courthouse when we're doing mediations?
Well, you know, that's something I really debated, because it's not under my purview, I think, to direct particularly private attorneys with regard to mediation and whether those are done in person or not. So really that administrative order is directed to those mediations that occur through the court. So that's in the family arena, in the juvenile arena, and criminal to some extent. So there's particular divisions where we use our mediation office on the 4th floor of the courthouse. And so for those, for a long time, nothing was being done in person, in family arena and so forth. And so I started getting called, can we open up the mediation? And it's like everything. I'm not sure it's completely successful to do these remotely. I am sure a lot of you have had great success conducting mediations remotely, but there's just some times when you want to do it in person. So the directive from my administrative order is really about court-ordered mediations and mediations that occur within the courthouse. So I'm sure, you know, if there's 2 private attorneys and you're doing face-to-face mediations, you're not really under the umbrella of the administrative order.
Understood, Judge. And actually, sticking with the mediation theme, we have a question. It says the administrative order seems to say that mediation in family cases is in person if the court decides that it can be. Does this mean just mediation at the ADR clinic at the courthouse? Oh, sorry, I just answered that. And if it's private, does it mean if it's private, does that mean it remains remote unless the judge on the case indicates it should be low? So yeah, that's a good question, because I think that AO talks about the judge has to determine that, but I think you just said if the parties, the private attorneys agree to have it off campus from the courthouse and want to go forward with the mediation, then the AO wouldn't apply to them. Is that correct?
Absolutely.
Okay, let's go to the next question then. When we start doing trials again, how will it be decided which cases get picked to be tried? What will happen if a lawyer is in trial in front of multiple divisions at the same time? Do you have any understanding as to how that will work out?
Yes, and that's actually I'm pretty sure it's in my administrative order, the priority, but it's really simple. We, of course, I know there's this great fear that we're all going to be busy doing criminal trials all day long, every day. And I might be wrong. I certainly feel like I'm in the minority when it comes to this opinion, but I just don't believe that. And so that's one of the reasons that I selected a couple of the civil judges to be part of this pilot project. And so speedy trials will, of course, when we go into phase 3 is when the clock starts ticking with regard to speedy trial. And given the fact that for the vast majority of 2020, there have been very few criminal trials, I anticipate that there will be several speedy issues. But you have to balance that with how many juries are we going to be able to sit on any particular day. We just don't have any clue what yield is going to look like. And we can also only safely accommodate in those 3 areas 160 jurors. So by the time you pull out all the people who can't possibly sit from that 160, how many do I have to send upstairs? I mean, even if we're doing short trials, that's 25 people. So speedy trials will be first, followed by circuit criminal, followed by circuit civil, and then county criminal, and then county civil. So that will be the priority order. Every judge who wants a jury on any particular week will send to my office how many jurors they need, how long the trial is expected to last, and what the case is about. And then in the chief judge's office, a determination will be made for the priority for the following week. But that's where I'll be looking. Speedy trial first, circuit criminal, and then circuit civil.
Okay. Getting back to jury summons and jury pools, can you provide any insight as to any additional criteria that will be used to excuse jurors prior to them coming to the courthouse or responding to the summons? And in regards to sending out the summons and getting a cross section of the community, given the fact that the impact of the virus is different based on different parts of the community. And one of the questions was the burden of women undertaking additional childcare and educational duties. Are there any additional steps being taken regarding the summons and getting people to the courthouse and additional types of ways to get out of jury duty, those type of things?
Dean, I think that's a great question. And we're seeing a lot of conversation about that, we all know we want a fair cross-section of the community. So in this time of COVID, are the prospective panels going to look the same as they did pre-COVID? So our summons, which we have many of, have already been printed, and there are particular reasons. By statute, everyone can get a 6-month postponement, and that's automatic by statute, and that's addressed by the clerk. That doesn't even come to the chief judge's office. So thereafter, we know that Justice Kennedy entered an administrative order, and I call it the Kennedy COVID questions. So if everybody's familiar with that administrative order, there were articulated 5 other COVID reasons. I've recently traveled, I'm a caretaker if somebody had COVID. You can see those in that order. So what we're doing is we send out the summons, and then on the 15th Judicial website and on the clerk's website, it tells individuals that if you have an additional reason that relates to COVID, you can punch it up, and there's another questionnaire that says, check one of these COVID reasons, and then that is electronically sent back to the clerk's office and then sent to my office. And I make a decision using discretion as to whether or not that's a valid reason to excuse that particular juror. Now, on a week-by-week basis in my office, I get stacks of letters from jurors telling me why they can't come to jury service. So we're going to be keeping track of that. So when I make that decision, we're going to have a folder of people who were excused for COVID reasons, people who were excused for other reasons, and those excusals or postponements that I denied. Because I think that, you know, there certainly will be conversation about, were 80% of the people who are 65 years of age and older excused, and therefore, you know, there weren't elderly people that were available. I know there's going to be a lot of issues that arise with regard to whether or not it's a fair cross-section of the community based on those excusals.
Understood, Judge. I guess this goes back to mediations and the ones that are going to be taking place in the courthouse. Are there going to be additional rooms? Because I know I've done a couple mediations in county court, and the rooms are fairly small. Are there going to be different rooms? How is the social distancing going to be done in regard to courthouse mediations?
Yeah, we're not going to go back to business as usual with regard to the mediations. There'll be 15 minutes in between for there to be a strict clean down in between mediations. We're starting off only using the extra large rooms. There will be maximum amount of people that are allowed in any particular room. So it isn't going to be as easy. You know, it might take a little more planning to get a mediation scheduled in the courthouse, because we're just not lifting the curtain and saying it's back to normal. We're only using the big rooms with strict guidelines on how many people can be in there. And again, a big clean down every time somebody leaves the room.
Understood, Judge. You said earlier that you guys are watching, obviously, the infection rates, and there's been a little bit of a spike recently. Is there a specific threshold rate you're looking for, or is it just take it day by day type of situation?
Well, we generally do a 14-day comparison to the prior 14 days, but Dean, it's a matrix. It's a matrix that I have of how to make a determination of whether or not we have to bump back. You know, I'm hoping with all my might that we don't have to bump back to phase 1. And I don't think that's going to happen, but none of us know, right? We don't know what's going to happen here during flu season. And certainly if we see a significant second wave and the numbers go through the roof again, then I'm obviously going to have to pull the plug on calling citizens into the courthouse. But I sure hope that doesn't happen, but it's not an easy answer. It's laid out in the work group study that was given to us, and you know, you can read it 3 times and still be going, what? What does this? So you know, my wonderful law clerks prepared a matrix for me that you know, I haven't even really, I know this, that we met all 5 benchmarks set by the Supreme Court for us to move into phase 2. And so with a leap of faith, off we went to phase 2. And so you know, I know this week was bad compared to the prior 2 weeks, so I'm buckling up to see what happens this week. But that's not definitive either. It just might mean I've got to take action to ensure that there's fewer people coming in to the courthouse. It's an astounding number of people that are coming into the courthouse on a weekly basis. In the main courthouse, there's 8,000 people entering the courthouse on any given week, which is astounding to me. I don't know where they're going, since you know, we're not doing that many. We have the clerk's office too, and I do get the numbers from the clerk's office of how many of those individuals are going there, but it boggles my mind when I see what the weekly numbers are of people entering our courthouses already.
Your law clerk never thought she'd be doing COVID matrices, or COVID matrices when they were in law schools, thinking they're going to come and do all this great legal work, and they're doing COVID matrices, right?
Right.
So regarding evidentiary hearings by Zoom, I'm assuming that there's not a standard procedure, and maybe there isn't, and maybe I missed it, or is it up to each judge as to how they're going to mark exhibits, procedures for how to go forward with evidentiary hearings in the Zoom world?
Well, I'm impressed with how many of our judges have been able to conduct non-jury trials and evidentiary hearings, and I'm impressed with the bar too for getting on with it. And I was speaking to a lawyer yesterday about it, and that people, I think, are being more cooperative and working with each other and saying, you know, can you stipulate to these pieces of evidence prior to us getting there and submitting it to the judge and reaching out a week beforehand. So I hope that that continues to go on, that the attorneys will work as cooperatively with each other to stipulate whatever exhibits you can. And I wouldn't say, you know, we always come back to this, they're all independent constitutional officers and judges are going to do it differently. But I know that for the evidentiary hearing, certainly it has to be provided in advance. And, you know, we've all been doing this for so long that I'm hearing it's going much smoother with regard to share screen and the evidence being pre-marked. So kudos to the bar for getting up to speed on how to do all of that and to provide it well in advance to the judge. I know it is important to the judges to have it well in advance and everybody be on the same page.
Getting more of the nuts and bolts of a trial, are there going to be plastic barriers between the jurors and attorneys in the courtroom? Those pilot jury trials you're talking about, what type of features are going to be in the courtroom in regard to COVID?
Another good question. Plexiglass has been a whole chapter of my life. I'm like, I don't know if I have to talk about plexiglass again, but it is important. But so anybody who's been into the courtrooms knows that we have quite a bit of plexiglass already. So there's a piece in front of the judge. There's a piece that separates the judge from the clerk with a little slide-through slot so that they can pass papers back and forth. The witness stand will have plexiglass on all three sides. And that's because all witnesses will remove their mask when testifying. We're going to certainly start off in the extra large courtrooms, and I don't have any fear that the witness stand is too close to anyone, but in an abundance of caution, we're going to have on all three sides the witness, and the witness at no time, once they get in the witness stand, will remove their mask entirely so that everybody has a good view of what they're saying and doing. And as far as the attorney table, for now, what I have decided in each case, I will leave it up to the defense and the plaintiff as to whether they want plexiglass on counsel table. So I know in some instances, there will be a request, say in criminal cases, for plexiglass between the defendant and their attorney. You know, I don't know how effective that is. They still have to communicate. Are they going to lean around the plexiglass? There's a security issue of whether I want mobile pieces of plexiglass on those counsel tables in particular types of cases. It's complicated. And then, you know how our jury boxes are. So in the grand jury room, it was pretty easy because they have tables in front of them. They sit in semicircles, almost like a county commission. So we were able to order plexiglass to separate each grand juror from the next one, and they're socially distant. But in the jury box, they will unequivocally be socially distant. We're going to X the mark and remove all other chairs from the jury box. But it's just not feasible. I can't put a dome around them, you know. So there will be a plexiglass partition in front of the jurors, but they're not going to be separated in the box. So there's going to be a lot of plexiglass, and everything we've ordered is mobile. So, you know, I have told all the judges in this pilot project that talk to your attorneys. And so if they want 2 pieces of plexiglass on each table and they want a plexiglass between the other side and them, then we're going to make that happen. So we got a lot of plexiglass going on.
I stock in the plexiglass companies, right?
Yeah.
This came up at Bench Bar actually, and it's another question in light of what's going on, especially now with school going back, but people still being virtual and maybe being quarantined and those type of things. Is there consideration to moving some of the circuit civil judges, or any judge for that matter, motion calendars to late morning or afternoon to accommodate attorneys and judges' children, remote school, home schedules? I know that I think Judge Curley said that he was open to it. And I think I've actually seen a couple judges actually doing 1 day a week, a 1 p.m. UMC or something like that. Has there been any further discussion about a uniform afternoon UMC ability for those particular times?
I actually received that request from Paul and sent it out to the judges. And I don't know any judge that objected to having one afternoon a week or just specially setting UMCs or those short hearings. If there are individuals who simply can't do it at 8:45, all of the judges were amenable to accommodating a time later in the afternoon to conduct those, because we certainly sympathize with those individuals. That I say it to my husband every day, thank God we don't have school-age children at home. So for those of you that do, we know how difficult it must be, and all the judges are sympathetic to that and willing to work with you. So I didn't hear back from anybody who said that they weren't amenable to that.
So that would be sort of contact the JA, see about if it hasn't been done yet, see if there's a process to go forward judge by judge.
Well, and I think some judges are saying I'm going to block off Tuesday afternoons, and other judges are more of the opinion that if you need a time, call my judicial assistant and she'll work with you on getting you in at a time in the afternoon that works for you.
Oh, this is an interesting question. Will you consider streaming the first trials that go so that other attorneys can view the process?
Yes, we will. We are going to, that's been another interesting issue during all of this, is there's the constitutional right to access to all court proceedings. So our IT department has been hitting it out of the ballpark and working so hard, but in all arenas, there must be access. And so when I made the decision in the administrative order to preclude the public from coming in, we had to address that challenge of access. And so every single judge, it's in the administrative order that you contact our public information officer, Deborah Oates, and no matter what hearing you wish to observe. Now, some of them, it might just be a telephone line that you can hear, but certainly for the trials, we are going to have access for all, and you'll be able to observe it in its entirety. So we're working on that, and I'm pretty sure it's going to be a WebEx. I don't know, that's an issue that came up this week, but we have gotten it down, and yeah, you can watch it from start to finish.
Along those lines,
it's probably going to be really slow because
well,
juror number 4. So, if you got time on your hands, tune in.
Well, I know that the ones down, I think in Key West or Duval, I think in Duval were some of them were streamed, and you got to see the actual trial, and I think it was an uncontested case. But it was interesting, but yes, it was long. It was, I think, 5 different YouTube videos that did that. In regard to the public viewing and public access, is there a portal that shows the UMC hearings and Zoom hearings that have taken place in the past for viewing, or how does that work? Are they stored anywhere?
Only those that the court is mandated to keep the record for. So that's criminal and juvenile. We are the keeper of the record in those courts. And so any hearing that has been conducted since March 17th, when this started, can certainly be ordered as a matter of public record. But other hearings, if there had been a request for access, it may or may not have been recorded, depending on what the type of proceeding is. But in civil, for example, no, all of those are not kept by the court or even particularly recorded, because that's not our statutory obligation. So if it happens to be in one of the courts where we must keep the record, then there is not a single hearing that we don't have a recording of and can provide as a matter of public record.
Understood. Going to the criminal arena, is there going to be a breakup between the felony division and the misdemeanor division to make sure that the misdemeanor cases are tried in the same, I guess, proportion to the felony cases?
No, priority will be given to felony. um, and as I said, the priority will be circuit criminal, followed by circuit civil. Top priority being all speedy trial cases. So a county criminal case where there is a speedy issue will take top priority, but circuit civil will take priority over county criminal. You know, Dean, I would say this. I don't want there to be the impression that the civil bar is going to lag way behind criminal, because I really don't believe that's going to happen. Listen, say there's, by the time we get done culling through the COVID reasons and we've got 150 jurors downstairs, there's just no way on any particular Monday that all the felony judges will be ready. We all know how it works, right? Everybody's like, yeah, we want a trial, we want a trial. And then on Monday morning, when we say the jury's coming upstairs, that's when everybody gets really busy and cases settle or last minute problems arise and continuances occur. So I frankly don't think there's going to be much of a lag, that we will, as I said, there'll be this priority list, and circuit civil will be right there in line for jurors when we see what happens on Monday morning. I sure wish, and we were hoping, all of us, and praying that, oh, it's going to be much more like it's really a trial on Monday, and we're going to be ready to go. But I think we all know this, that it's funny, even in this, we're doing this pilot, you know, so the judges are culling out 4 or 5 easy cases, and guess what's happening? Guess what's happening? They're settling. So it's the whole, here they come, you hear them? They're getting on the elevator, and everybody gets busy. So I don't know. I was saying, well, let's do it every week. Call up 6 and say, you're going to jury trial, and watch them fall.
Some things stay the same no matter what, right?
It's so true.
Trial, the settlement happens.
It's so true.
In talking about Zoom depositions and hearings, is there going to be a uniform, I don't want to call it procedure, but uniform policies about how they need to be conducted in regard to, you know, camera presence, communications, backgrounds, basic ground rules for not having somebody else off camera, those type of things? Or is that left up to the individual judges as to how they want to handle that?
Well, we don't have any uniform procedure with regard to that. I mean, with regard to the depositions, I have so much that I'm directing and deciding to do, but I'm certainly not going to step in and start telling people how they need to conduct their depositions. And so it'll be up to each judge to think whether it was sufficient. I know this, during depositions, during this time, a lot of the judges are making themselves available, as they did prior to this, but I think judges are being called upon more often during this time to intercept during the deposition. You know, if somebody raises an objection, that the judges are telling me that they're taking phone calls and getting on the phone with the attorneys to make determinations about what should be done or how it should be conducted. So I think that that's occurring a lot more than it did pre-COVID.
And how do you see, talking about Zoom depositions and summonses and things of that nature, are there specific or different instructions that need to be on the summons? Or are there any, from your perspective, any additional things that need to be done contingency-wise as to whether they can do the depositions in their home, or they have to go to a certain place to provide their testimony? Or is it, again, just like we just talked about, is that just up to each individual judge?
I think not only each individual judge, but it's just up to the parties, you know. So I know that, especially in the criminal arena, that there were a lot of objections to particular hearings being done remotely. And so now that we've opened up the rooms in the courthouse where a lot of the criminal depositions occur, that we're starting to see a lot of activity there because they weren't satisfied. You know what, Dean, I think it's true for all of us. When we first started out doing this, you know, that a lot of attorneys felt like, oh, gosh, I don't want to have my hearing on Zoom. I need to be there in person so I can impress the judge with my great legal skills and argument. But the longer we've done it, I think people are assimilating and acclimating to the fact that it really can be done, and you're going to win just as often based on your great skills via Zoom. So, you know, I'm trying not to, I'm trying to stay in my lane. So, you know, directing how depositions or mediation occurs is really not under my umbrella, and I don't need anything else under it. So, you know, if there is an objection or you just can't get it done, there have been motions in front of judges with regard to, judge, will you order this mediation to be in person? And all of the judges I've talked to have said, I'm not going there. That's not up to me, and it's up to the parties. And if you can't get it done, then you can't get it done. And when we start teeing up trials, you know, so I think that's going to help, that at least we're saying you can do it in person, but it's up to the parties to decide what they want to do.
So speaking about, you know, this is obviously a moving target, fluid situation. As the bar, you know, as lawyers, if we see something that we think could be helpful, what's the best method to get to you? Or is there a suggestion box or an email or the website where, you know, we may be able to offer suggestions that maybe help both the bench and the bar?
Well, I've been getting lots of suggestions. I don't know if I need to open that up any more than it is already, because there isn't a day that goes by that somebody doesn't give me an idea or a suggestion or an opinion. But it's really helpful. I mean, I've been trying to meet with the judges on a fairly regular basis, because certainly on the 5th floor where we're administration, we're not thinking of everything. So I really think the best thing to do is to reach out to the administrative judge of that division with what the idea is. And then, you know, frankly, in the guardianship area, there have been a lot of requests for things to be done differently, or that we take a look at what's in place right now. And so, you know, I have a director that's in charge of that, and she communicates with the judges that are handling guardianships. And we want to know, we want to serve you better. We want to do the best we can. And there's stuff that we just aren't thinking of. So we are completely open to that. But that would be my suggestion, is that you first go to the administrative judge, and that's brought to the attention of whoever the director is over that department, and we will get back to you.
And of course, things like this are always helpful too, because people can ask questions. And to that, please ask more questions for anybody that's hesitating. There's not much time left, so if you have a question, please post it. As lawyers, what can we do to help judges carry out their duties? Meaning, you know, how can we make it easier on the bench when we're doing our job, so that we can get the best results for our client and get everything moving more efficiently for the bench?
Well, I think the bar has been exceptional during this time. I would remind everybody, and I think it should go without saying, that even if you are appearing remotely, you should treat it as though you are appearing in court. And so I think most judges would tell you that there has been a much more casual attitude. And, you know, so when you're in court, you're dressing for court, you're not addressing, because, you know, it's Hollywood Squares. And so I think people are seeing attorneys talking to each other more, rather than directing it to the court. The use of first names, that I think when you're home, you adopt this more casual attitude, and that's bleeding over a little bit into the hearing. So I would just remind everybody about civility and professionalism, and that even if you're home on your couch, that, you know, you should dress for the occasion and act for the occasion. But all in all, I think people have been doing a great job.
Understood. I guess the question I have is, and almost all of these questions, actually, all of them except one have been from the people watching. And we have got a lot of people on on the call today. We're doing criminal in October, civil in November. Is there then going to be a December, roundtable about where we do next? I guess we're just trying to figure out, where do we see December, January, February, March?
Well, October 14th will be the grand jury. And then the following week is when we're going to bring the first round in for circuit criminal. And then the week after that, again, circuit criminal, followed by the first week in November is when we're going to do civil. I am then going to have a full court after we do this pilot with all of the judges to talk about how it went and what we saw the problems that arose, what occurred. And, Dean, it's hard to say because all you have to do is turn on the news and there's this whole, let's panic, the second wave is coming. And I don't know, maybe it is. So really, I have in my mind a date that I think the curtain's going to drop and we're going to rock and roll. I do. I have a firm date, but I don't want to say it because I don't know. In 5 weeks, I could be contemplating we got to go back to phase 1. I hope that isn't true. And I'll say this about December, I'm certainly open to, I think that would be a good time to chat with the bar again about where we are. I'm hoping that I'm going to be saying we're going to phase 3, ladies and gentlemen, but I'm also, we might be ready to do that at the end of November, but I'm not going to do that because we've got Thanksgiving, we've got Christmas. We also, I think, certainly in the courthouse and with the partners and those of you who run big firms or small firms, that we're going to all have to get back to the idea of we're going back to work now, and full force, because we've all kind of, I'm sure some people are at 100% and doing just as much as they were before, but it's going to be a bit of an adjustment for, getting back to how we used to be. So I just don't anticipate I want to do that between Thanksgiving and Christmas. I sure hope the numbers say we could. And, but yeah, December will be a good time to take a look at how are we looking? And are we going to phase 3? I hope so.
I sense a December town hall coming up then, so maybe we'll do that in December. Is there going to be another interim step? I know we talked about the order of the next cases that are going to go, but is it going to be another set of pilot trials, or are we just going to, at that point, once the pilot trials go, is it then going to be almost all the judges are going to be doing the trials at that point?
That's what I anticipate. I mean, I really think we're going to somewhere, I'm hoping we can get about a half a dozen trials done for the remainder of the year. That's what I hope. And that we will learn. I mean, yesterday I was down there in the breezeway trying to figure out, we got to get, like they have at the elevator, the serpentine markers to tell people where to stand, the jurors. I want to separate the jurors from the other public coming in. There's so many complex issues, but no, I'm hoping this measured approach to stepping back into jury trials will teach us enough that a few months after that, when we enter phase 3, that I will go to that plan where every judge will send to me, this is how many jurors I need, this is what the type of the trial is, this is how many days I anticipate it will be, and then we'll have a matrix of who's going first.
Another matrix.
Yeah, so that isn't going to be particularly fun, but there's just no other way to do it, so, and maybe this will present so many problems that I'll do another round with a larger amount of judges. I don't know, but I hope that we'll be able to open it up to all the trial judges. Because really, you know what the big problem is going to be? Getting enough jurors to show up every day, I think. But maybe not. We're going to learn. We're going to learn what yield looks like post-COVID. And I can tell you across the state, it has not been as dismal as we thought it would be. So in Tallahassee and other places where they've done some trials, their yield is about 27% compared to, they had a higher yield than us in South Florida. So we'll be the first in South Florida to dip our toe into the water. And it's going to be interesting to see if we're much different from the rest of the state.
In regard to the pilot jury civil trials, in the garden variety, quote unquote, cases, is there going to be, one PI case, one commercial case? Have you figured it out which of those types of cases are going to be tried in the civil division?
I have left that up to the judges that I've spoken to who will be doing the trials, with the proviso that it cannot be more than, say, a 3-day trial, which I know can be difficult in circuit civil. You know what else I think it's going to be good for is everybody's used to, oh, just bring us 100 jurors, bring us 80 jurors, that all of us are going to, if we want to move forward, maybe have to get used to the idea that you need to try to get it done with fewer jurors. So, for those people, I get requests all the time, I need 200 jurors. You're not going to be very high on the priority list of who's going to get jurors that day, because we won't have 200 jurors. We can only accommodate 160 bodies in those 3 locations that we're going to use for jurors. So I do think there's going to be a lag for those super long civil cases that need a lot of jurors. That's going to be a while.
Understood. Would you consider an AO that requires counsel to advise the court if there's a court reporter present? I guess on phone, because on Zoom, their window would pop up. But if there's a court reporter present, I know since we're all on phones, we sometimes don't know if there is one or not. But is there any type of, have you had that issue pop up where court reporters are taking testimony for one side essentially that hires them, but then the other side doesn't know that there's a court reporter there and isn't available to get the transcript because they didn't know that it happened?
It's interesting. I haven't heard that issue raised, because I guess I'm just assuming on Zoom, you see that the court reporter is there and all parties know it. But I guess if there's a telephonic hearing, you're absolutely right. And it certainly seems like it would be best practices for the judge to say, please announce yourself if you're present on the call. No, I'll certainly consider it and talk to the judges about what they think the best way to handle that is, because it's only fair that everybody knows whether it's being recorded or not.
And this is a question that I think I know the answer to, but I will pose it to you anyway. Do you think some people will continue to maintain remote or mostly remote practices from the, in the near future? And if so, how does that affect how the courthouse is going to be running?
Well, again, what a variance it's been with regard to the 54 judges. Some of them love this remote hearing, and I know we all know this too, that some people are a lot more careful and fearful of COVID, and some are more willing to take a little bit of risk. We're all over the scale on that, just in regular life and also amongst the judges. So I think that's going to vary from judge to judge with regard to how many hearings they conduct remotely, and whether, because all the time motions are coming in as to whether it's feasible electronically to go forward with the hearing remotely. And so judges are hearing those matters day in and day out, and you're going to get a big difference on opinion amongst the judges. So some will hang on to it and continue to do it a lot, and some don't like it a bit.
Understood. Juror deliberations, they're going to be moved to a different room, or is there going to be some sort of additional things in the jury deliberation rooms that, I guess initially they'll be in probably a bigger room in the ceremonial courtrooms, but the jury deliberation rooms, are those going to be the same ones, or we're going to move to a different room?
Well, for this pilot program, the jury rooms that are attached to the extra large courtrooms, we've already started. We have moved out every single thing, including extra chairs. So there will just be 7 chairs in each jury room, and everything else is being completely sanitized. And I am cordoning off those rooms because sometimes people go in and pop in and out. So they will be just hosed down and cleaned to the furthest extent possible. And then we're going to cordon those off with all furniture removed. So during breaks and so forth, we've already social distanced those rooms and moved the tables accordingly. It'll be X'd off on where each juror sits. In each of those rooms, we're going to have 2 air purifying machines, and our facilities is going to come in on a regular basis. And at no time will anyone but a juror be able to enter those rooms. Now, during deliberations, what we're going to do is shut down the courtroom. So everybody's going to leave the courtroom except for the jurors, and the front doors will be locked, and no one will be able to enter the courtroom until they knock on the door where the deputy will be sitting out to reconvene everybody. So deliberations will occur within the courtroom, and all audio will be turned off. Obviously, we won't be listening in to deliberations.
Great. Well, it looks like we're approaching the end of the hour. Judge Marx, we could not thank you enough for being here today, answering all these questions. We got through all the questions, thankfully. We'd like to thank everyone for coming today. Please go to www.palmbeachbar.org for all the COVID-related things with the courthouse. We have all of Judge Marx's AOs on there, programming to help you get through the COVID crisis pursuant to our Vision 2020 focused on a recovery initiative. And Judge Marx, we will see you in December, if not before then, hopefully for our next town hall. Do you have any closing remarks, Judge?
Just thank you very much. I think that this exchange of communication helps everybody. And I just want you to know that the judges and all of us in the 15th want to make your life as easy as possible. And first and foremost is keeping you safe. And secondly, we are all available to keep the cases moving as best as we can. And I just want everybody to know that we are available and ready to hear whatever it is you need heard. Thank you very much for joining today. I appreciate it.
Thank you, Judge, and thank you for everyone for attending. Have a great weekend.
Bye-bye.